At the Umansky Law Firm, we believe everyone deserves a second chance.
My name is Lindsay Gergley and I'm a criminal defense attorney in Orlando, Florida. When I get this question from clients, I first have to evaluate the facts of their case. If we're dealing with a misdemeanor battery or assault case involving somebody that they're in a domestic relationship with, we first look to see what the victim in the case wants to do. A lot of times, victims in these cases, because it does involve their loved one, don't want to go forward with prosecution in the case. They may have just called the police to defuse the situation and their loved one ended up getting arrested. If this is the case, then we normally will contact the victim ourselves and ask them if they would fill out an affidavit of declination of prosecution. This affidavit is a sworn document that we will help them get notarized in our office, saying that they don't want to go forward with prosecution and then they are no longer in fear. We have to be very careful when asking victims to fill out the declination of prosecution because we definitely do not want to be seen as tampering with witnesses. However, if the victim is willing to fill this piece of paper out, we are more than willing to help them. Once we get this filled out, we will then send it to the state attorney's office. Some victims of cases have fears about speaking directly to the state attorney's office because they feel they may say the wrong thing and get their loved ones in more trouble. If the victim doesn't want to go forward with the case, that is not a guarantee that the state attorney's office will drop the case against our clients. A lot of state attorney's offices in the Central Florida area will look to what the victims want. However, it is not an end-all be-all in their charging decision. If they decide to go forward with the case, and most importantly, if the victim wants to go forward, we are then looking for the best resolutions. Most counties in the Central Florida area have a first offender program for domestic violence. Different counties have different requirements. In some counties, you can negotiate the terms of this first offender program. In some counties, they require the 26-week batterer intervention program. This program is a program that, while not difficult mentally to complete, it does require a lot of commitment from the client. Some counties will allow a 12-week class or even an 8-hour anger management class to complete the first offender program. The good thing about first offender programs is that the case will be dropped at the end. Now, if the victim or the state attorney's office will not put our clients into the first offender program, or if they don't qualify for the first offender program, then we are looking to ask the prosecutor for the best available deal. Probation with conditions, maybe a reduced charge, anything that will help the client keep a relatively clean record.